Good morning. Welcome. This is Sherman & Howard's webinar presentation on differing site conditions. My name is John Mill, and I am one of the senior lawyers in Sherman & Howard's Construction Industry Practice Group. I am pleased to be here today to introduce our presenter, Ryan Klein, who will be discussing several important issues regarding differing site conditions. Today we have over 100 people signed up for today's presentation. The audience includes representatives of contractors, subcontractors, home builders, developers, and public entities, as well as experts, insurance professionals, and attorneys. That pretty well covers the types of clients and others that we work with, and we thank each of you for joining us this morning. Let me cover a few logistics before we get started. In the unlikely event that you are disconnected from the presentation, please reconnect by going back to the same link you initially used to sign up into the webinar. If you have any technical difficulties, please call 800-843-9166 for immediate assistance. Again, that number, 800-843-9166. We encourage you to ask questions during this presentation. You can submit questions during the presentation using the chat box on the left of your screen. We have reserved some time for Q&A at the end of the program. We are recording today's program. We will circulate a follow-up email to all participants later this week with a copy of the audio recording and the PowerPoint slides, which you can share with others or continue to use as a resource, so keep an eye out for that. I'd like to also invite everyone attending today's presentation to also attend Sherman & Howard's annual Construction Law Seminar. This year it will be on Friday, February 26th at Sports Authority Field at Mile High in Denver. We will provide breakfast and the program will start at 8 a.m. We will have about 14 different speakers on various topics of interest to those in the construction industry. Each presentation will be no more than 10 or 15 minutes, so we keep it fast-paced and lively, and the seminar will conclude by 12 noon. Watch for an invitation in your inbox, but if you don't get an invitation, you are welcome to contact me or Ryan, and we will make sure that you get one. Now, it's my pleasure to introduce your presenter, Ryan Klein. Ryan is a member in Sherman & Howard's Construction Industry Practice Group, working out of our Colorado Springs office. He has over 10 years of experience representing clients in government contracts, construction, commercial litigation, and employment matters. His government contracts experience covers all types of federal, state, and local projects and covers the entire procurement process from award to claim and litigation. Ryan, all yours.
Thanks, John. So as the name implies, we're going to discuss differing site conditions today. So what are differing site conditions? When someone's presented with a differing site condition, you can feel perplexed, confused, kind of like the image here. And we're going to try to explain what are differing site conditions and some of the different issues associated with differing site conditions, first by just discussing basic background, definition, purpose. We'll then talk about the two different types of differing site conditions and how you determine whether a condition that you encounter is in fact a type 1, a type 2 differing site condition, or none of the above. We'll then also get into some tangential issues relating to differing site conditions, such as notice, how to seek relief for differing site conditions. We'll then also talk about specifically Colorado law on differing site conditions. And finally, we'll talk about some best practices as to how to avoid differing site conditions, and then how to deal with differing site conditions if you encounter them. So a definition of differing site conditions. And this comes from the Means Illustrated Construction Dictionary. Unanticipated physical conditions at the site that differ materially from those set forth in the contract or ordinarily encountered in work of similar nature. Now, that may be easy for you to understand or may be confusing, and we'll kind of break that down into the different types as we discuss this throughout this webinar. So the purpose of the differing site conditions. There's probably a lot of purposes, but the general purpose is to allow contractors to submit more accurate bids. Now, how does this happen is differing site condition clauses eliminate the need for contractors to include contingencies in their bid to account for unknown conditions. Now, who does this benefit? At least in theory, it benefits everybody. Contractors get protection for unanticipated conditions, so they don't have to worry about finding something they didn't anticipate. And the government gets more accurate bidding. So instead of receiving bids that are inflated to account for contingencies, they get bids that are, at least in theory, more accurate. Now, the type of law that we're going to be talking about today, it's primarily going to be the Federal Acquisition Regulations, which, if you've done any kind of government contracting, you know this is the law that generally applies to the work that you perform when providing goods or services to the federal government. And then we'll also be dealing with the interpreting law of the Federal Acquisition Regulations. A lot of this will be dealing with the Federal Acquisition Regulations because it is the most developed body on differing site conditions, and a lot of states tend to either follow the FAR or its interpreting case law. We'll also talk briefly about Colorado, and as we'll discuss, there's really no statutes or regulations on differing site conditions except for the Colorado Department of Transportation, and then we'll briefly talk about some limited case law. And finally, if you're dealing in the private realm of a private construction project, you'll need to look at your contract and then whatever the applicable law may be. Even if that's in Colorado, your law may be another state. Now, throughout much of this presentation, I'm using the phrase government, and that is intended to apply to both the government and the owner. I use the term government since a lot of these principles come up in the realm of federal contracting or state contracting, but the principles equally apply to an owner substituted for the term government on a private project. The types of differing site conditions. There are two different types. First, we have a Type 1 differing site condition, and these are conditions that materially different from contract documents. And then second, we have a Type 2 differing site conditions, and these are unknown and unusual conditions. And we will discuss each of these in much more depth in the slides to come. So let's take the first type, Type 1 differing site conditions. The FAR describes this as subsurface or latent physical conditions of the site which differ materially from those in the contract. And then in the private realm, looking at AIA A201, defines it in a very similar manner. Subsurface or otherwise concealed physical conditions that differ materially from those indicated in the contract documents. Now, digging a little deeper, these are the 6 generally recognized elements for differing site conditions. And we'll talk about each of these in the slides to come. I won't read these now, but looking at these elements, we'll focus particularly on the second and the fifth element. So the second element is the contractor acted as a reasonably prudent contractor in interpreting the contract documents. And the fifth one, the actual subsurface conditions were reasonably unforeseeable. Disputes on differing site conditions generally come down to these elements, and we're going to particularly focus on these 2 elements, although we will talk about all 5 of these elements throughout the presentation. So the first element is contract indications. Now, this has a fairly expansive definition. It doesn't include just the solicitation documents. It also includes any document that is referenced in the solicitation. So this could be drawings, this could be soil borings, it could be geological reports, and it could be soil surveys. One thing, though, this doesn't include is any documents that are produced during the performance of construction. Now, to satisfy the first element, there has to be affirmative indication of subsurface conditions. It doesn't have to be explicit or specific, but it still must have sufficient enough detail, though, that one can say that there is an indication of a subsurface condition. Now, following on that, it doesn't have to be express only. It can be implied. And there are cases, for instance, where concrete drawings imply that concrete was approximately 6 to 7 inches thick. The solicitation didn't specifically say that, but one could reasonably infer that. Also a case where there is a designation of a specific borrow areas, and this was an implication that a board found implied that sufficient material would be found in those borrow areas for the job. At the end of the day, if there's no indication in the contract documents, there is no Type 1 differing site condition. For the second element, whether the contractor acted as a reasonably prudent contractor in interpreting the contract documents. Now, I've put this little thing I found on the web here because who is the reasonable person? It's something that sounds very abstract to find out who is a reasonable person under the circumstances. And I'll try to explain that in a little more detail. So here you see at the very top the rule that many of the boards, the courts, and even state courts follow is a contractor has to act as a reasonable contractor under similar conditions. And the key there is similar conditions. So courts and boards will look at the conditions that the contractor had and encountered in determining whether they were reasonable in interpreting the contract documents. So a contractor can't misconstrue the documents. A contractor can't base its understanding on a misunderstanding. A contractor must come to its conclusion based upon all the relevant documents. So it can't look to one portion of the contract documents to the exclusion of others. So if there was a contract indication in one portion of a contract document, but 5 other references throughout the contract, more than likely relying on the one indication would probably be unreasonable. And one of the issues that comes up is boring logs. In many instances, you will have boring logs in specific places throughout the project, but you may not have boring logs throughout the project. So contractors will have to determine what is the conditions in between those boring logs. And what the courts say is contractors have to reasonably interpret those boring logs and come to conclusions as to the subsurface conditions between them. Now, one example that would not count, and this is a case, is where a contractor looked at the boring logs and came to the conclusion that between every boring log, the subsurface conditions were the same type and quantity of materials throughout the entire project. Now that probably more than likely in most instances is not going to qualify as a reasonable interpretation of contract documents. A contractor is presumed to have the general skills of a reasonable contractor. They don't have to be an expert, but the court will still factor in the actual skills and knowledge. So if a contractor does have a higher level of knowledge, maybe something reaching the level of an expert, they are going to apply that in determining the contractor's interpretation. And finally, and this is maybe most importantly, is the interpretation doesn't have to be the only reasonable interpretation. It just has to be a reasonable interpretation. So the court won't take a hindsight look saying that this is the only way you could have done it. As long as the contractor's interpretation was reasonable, the court will find that the contractor has satisfied this second element. Of course, at the same time, it can't be reasonable interpretation if there is patent ambiguities or problems. And in those instances, as we'll talk about under best practices, a contractor has an obligation then to inquire of the government or the owner. So the third element, a contractor must reasonably rely on the indications of the subsurface conditions in the contract. Now, usually this is an easier element to satisfy. Of course, claims can fall apart in any of these elements, but compared to the other elements, this is easier. But a contractor still will not satisfy this where it doesn't review or consider the contract indications. So there are cases where contractors just didn't review the boring logs or geological reports. When they attempt to rely on those, the court said if you don't reasonably rely on it, then you can't use it as a basis for a claim. It also is not satisfied where the contractor has knowledge from prior experience. In many instances, you may have contractors who've performed numerous projects on certain projects, especially military installations, and they may know of unique circumstances there. And in those instances, the contractor can't just rely on the contract documents and put its head in the sand and ignore what it knew from previous projects. The fourth element, subsurface conditions actually encountered differed materially from the subsurface conditions indicated in the contract. Here's a picture from a project site of conditions that someone encountered as to groundwater. There's really little discussion in the cases about this element. It is, again, tends to be one of the easier ones to satisfy. Ways you can satisfy this if you had to proceed to a court or board hearing is you may conduct testing when you encounter the condition. Pictures are obviously a great idea, and we'll talk more about those. Courts and boards have found that a contractor can establish it through just even increased effort in having to perform the work. And additionally, many times you'll find admissions by the government that there may be conditions that materially differ. And we'll talk more about where you might find some of those. But still, if a contractor cannot prove that it encountered conditions that materially differ from the indications in the contract documents, it'll still lose the claim. And this comes up quite often where there is a lack of documentation, and then you're only dealing with the testimony of a contractor versus the government personnel. And I've seen instances where courts and boards have denied claims on those bases alone. So this is something we'll talk about in best practices to make sure that in case you encounter a alleged differing site condition, you don't have that same issue down the road. The fifth element, and this is the actual subsurface conditions were reasonably unforeseeable. Now, the standard for this is an objective reasonableness standard. So what that means is, again, the court is using this reasonable standard, but they're using it in an objective fashion, meaning what would a typical person do under the circumstances. It is fact-specific, so courts and boards will look at what were the facts of the case, and taking all of those facts together, what would this reasonable person, this reasonable contractor, have concluded as to whether these conditions were reasonably foreseeable or not. Now, this element often interacts with another provision in the FAR. This is the Site Investigation and Conditions Affecting the Work Clause. And you can see it here at FAR 52.236-3. And this is often a clause that the federal governments will bring up in cases, and if you have similar state or private provisions, I would expect an owner or a state municipality to bring up as well. So at least summarizing the federal FAR provision, contractors must take all steps reasonably necessary to ascertain the nature and location of the work and to satisfy themselves as to the local conditions affecting the work. So what this requires contractors to do is they have to look at all of the information. This includes contract documents, so all those type of documents we referred to earlier, as well as the site inspection. The contractor is not required to look at information outside the contract documents, so they don't have to go down to some local geological repository of information and look at other information. Additionally, a contractor doesn't necessarily have to have the knowledge that some of its competitors might have. But there is a caveat to this. If one contractor has one belief and 30 other competitors have a different belief, there may be a question as to whether the one contractor who's in error, who's claiming the differing site condition, should have known that based upon the local geological conditions. But there is no requirement that during preparation of a proposal, a contractor has to contact all its competitors to find out what they're thinking. Odds are the competitors probably aren't going to give that information anyway. If there is a discrepancy, generally contractors are going to be required to go back to the government and ask questions. Now, unfortunately, contractors can't rely on the fact that they may be a small disadvantaged business. They cannot rely on the fact that this is a new location for work. So maybe this is the first time they're moving into a new state that has different geological conditions. The court is going to, as we mentioned, look at an objective reasonableness standard, And a contractor who's moving into new areas may need to seek some help. Now, a contractor doesn't have to engage in any time-consuming or costly technical investigations. And so you don't have to open walls, you don't have to perform your own borings, and you don't have to do any ground-penetrating radar. And I currently have a case where the government suggested that my client should have used ground-penetrating radar to identify the subsurface conditions. And when pushed, they of course couldn't find any case to support that. Additionally, a contractor doesn't have to hire experts. And finally, if the government requires a greater level of specification than this clause, they have to specifically identify that. Now, there are some exceptions here. If the government prevents a contractor from performing a site investigation, the contractor may be off the hook. So if the government won't allow access to certain areas, the contractor can't be expected to identify information in that corded off area. But of course, the contractor really has to be careful because that ends up being an area of dispute. So my recommendation to clients would be is if that is the case, is document it. Document the request and document the denial. So down the road, there's not a dispute. The other one is impossibility. In some instances where contractors perform work, it may be virtually impossible to identify the conditions. For instance, one case, a contractor was off the hook for looking at the amount of sediment underwater in a canal. But again, contractors have to be careful because court's going to look back at this at an objective reasonableness standard. And if the court doesn't find it impossible, then a contractor is not going to satisfy this element. Looking at this cartoon I found, exculpatory clauses, so clauses where contractors try to get out of their obligations, and you can see everybody blaming each other. And this is something that often happens in government contracting, is the government tries to put the blame on the contractor. And you can see here in this example, this is a clause that I have in a current case where the government tried to move the burden onto the contractor to have to determine where underground subsurface conditions were. Now, generally, the courts and the boards disfavor these type of clauses. And the reason being is they override the differing site condition clause, and most particular, they override the purpose of the differing site condition clause, which is accurate bidding. So because of that, courts very strictly interpret these clauses. And you'll see in a lot of cases that the courts very often, and probably maybe as much as 75% of the time, do not enforce that. But at the same time, you have to be careful, is courts will uphold these clauses where they are clear and ambiguous. So in looking through a solicitation or with a procurement or in dealing with a contract for a private construction contract, contractor needs to be conscious of that and be very careful of the language. Now, even at the end of the day, even where there is a clear and ambiguous clause like this, the courts or boards still may not apply them if there is an express indication as compared to implied. So in some instances, the courts have said implied indications can be waived, but express indications, the government or the owner is still going to be on the hook. And the sixth element, the contractor's claimed excess costs were solely attributable to the material different subsurface conditions. Again, this is an easier element to satisfy as compared to the second element and the fifth element. But still, looking at these bottom 2 points here, it's not always something that is going to be automatically satisfied. So one, excess costs will not be authorized where there are concurrent causes. And so concurrent causes could occur where there are delays caused by the contractor on some other condition. And in those instances, especially in federal government contracting, boards and courts aren't going to give contractors relief even though there are differing site conditions because of those other delays caused by the contractor. And finally, the contractor still has to establish its cost through some damage calculation method. Now, there are a variety of different types. I'll point out four. Four of the ones, at least the major ones, are actual costs, total cost method, modified total cost method, and jury verdict. And I'm sure either you know these or maybe you've heard these in other webinars. Between these different methods, the preference always is actual cost method. So being able to prove that because of XYZ differing site condition, you had very specific costs. When you're dealing with these other methods of trying to show that comparison of what you bid the job versus what the job cost, which is part of this total cost method, courts are very wary of that under the case law, and you run the risk of not getting any compensation when you're using those methods. So that's type 1 differing site condition. Type 2 differing site conditions are unknown conditions that are not usual for the location where the construction is being performed. And you can see the definition here from the FAR and from the AIA. So again, unknown and unusual subsurface conditions. This is often misunderstood. People just assume that if they encounter anything they think is remotely out of the ordinary, it automatically qualifies as a differing site condition. And as we'll talk about, this really isn't the case. And the courts and the boards hold that there is a very heavy burden in a type 2 differing site condition. So it is not something that you can easily rely upon, although it definitely does happen and occur. So these are the four general elements. One, you have to prove what are the recognized and usual physical conditions. Second, what are the actual conditions encountered. Third, whether or not the actual conditions encountered differed materially from the known and unusual conditions. And then fourth, the actual conditions caused an increase in the cost of performance. Now, some of those, as you can probably see, are fairly easy to establish. The real key here for type 2 is this third element, is whether we have unknown and unusual conditions. And this is the key, because this is where a claim for a type 2 differing site condition often fails. So the first part of this is whether the condition is unknown. An unknown condition is a condition that one could not have reasonably anticipated from the contract documents, inspection of the site, or the contractor's general experience. And courts and boards are going to look at all three of those. So contract documents, whether you look at them, when you inspected the site, did you see it or reasonably should have seen it? And then also looking here, the contractor's general experience. So again, like with the type 1, if a contractor has experience with a certain area, they can't claim that a condition is unknown. And there's one case dealing with an Alaska project where a contractor tried to claim that there was an unknown condition related to permafrost. Now, this contractor had performed work in that area before, and the court said, you've been here, you know about this, it can't be unknown. Now, again, with this, the contractor is not held to an expert knowledge standard. Second, the condition has to be unusual. So it has to differ from what's expected in the geographic area. It doesn't have to be a geographical phenomenon. So it doesn't have to be the strangest thing that's ever happened in the history of the world, but it still does need to be at least somewhat extreme for the location in which you're at. The best way to describe this is to talk about examples. So what are some cases where there's been differing site conditions? First is demolition debris while installing electrical or underground electrical conduit on an Army base in Colorado. And what the contractor found was unknown structures, abandoned foundations, and abandoned runways. The government tried to argue the contractor knew from prior experience about hard, rocky subsurface conditions, but the board said that there's no reason they could have anticipated this. The usual conditions were just clay and river rock with some possibility of hard rock, but asphalt, concrete, rebar, and debris were unknown and unusual. Second, sewage during an excavation project to build parking garages for congressional buildings. Now, in this instance, the contract drawings did not show a sewer line. It only showed a storm sewer line. And the court, in finding that the conditions were unknown and unusual, said, while a contractor could have reasonably anticipated water, sewage was something that was unusual. And finally, and this is maybe the most interesting one, is a case where a contractor encountered what the court called, quote-unquote, a tremendous amount of muck while building softball fields in Florida. And this was a case at an Air Force base outside Pensacola. So you might, probably like the government argued, think that, well, of course the contractor should expect these type of conditions. Prior to the job, the contractor walked the site, didn't see anything regarding muck. The ground looked dry. The site was flat. This was confirmed by the subcontractor and the architect and the engineer. And even the maps showed the area as being a wood or brushwood area. Now, ultimately, in the end, the contractor encountered over 600 cubic yards of muck. And when you think about that, even that in of itself is a lot. But when you look at how much it was throughout the project, it was even more. So 2/3 of the entire site had muck, and in some areas up to 3 feet. And the board shut down the government's arguments that because this was near the Gulf or it was near swamps, the contractor should have encountered muck. And the board did this in part based upon where this site was within the project area, within the base. Some areas you might have had an issue of muck, but because this was up on a higher ground away from any potentially swampy areas, it was a Type 2 differing site condition. Now on the flip side, some examples where courts and boards have not found Type 2 differing site conditions. In one case, a contractor encountered expansive clays while constructing duct banks at Dallas-Fort Worth Airport. Now, the contractor during this year had encountered unusually severe weather, more than double the amount of rainfalls. But at the end of the day, at the hearing, both experts for both the contractor and the owner agreed that the contractor should have reasonably anticipated heavily expansive clay. And even the soil survey maps showed clay as well that the map noted would be hard to deal with. And because of that, the court said that this was not an unknown or unusual condition, even with the weather. The second case of excessive groundwater while building levees near Missouri River almost kind of seems self-explanatory. And then finally, a contractor encountering a bed of conch shales while dredging near a Navy base in Georgia. The board found that this was not unknown or unusual, primarily based upon boring logs that showed the presence of shells, shell fragments. Now, the contractor tried to argue the difference between some amount of those versus concentrated, but this is kind of the difficulty of Type 2 differing site conditions because it is a very heavy burden. Now, this next slide is, I don't know for sure if it's true or untrue story. I believe it to be untrue. But there's an alleged story, maybe an urban legend, that contractors working in Florida building culverts encountered an 18-foot alligator while building this part of the project, as well as finding 87 snakes. I found one website purporting to say this was a real Type 2 differing site condition. When I end up finding this on a website, Snopes.com, I question as to whether this is real or not. But it poses an interesting question. If you were constructing in Florida and you encountered a alligator, that may not be a known or unusual condition since they are known to be in Florida. But it could be a question as to whether an 18-foot alligator is something that you should have expected or not. Now, the second one obviously is probably a lot easier. If you encounter 87 rattlesnakes in Florida, I think that is an unusual condition in the sense of rattlesnakes are not indigenous to Florida, but southwest United States. So I think at that point you probably have a decent argument that that would be a Type 2 differing site condition. So how do you determine if, in fact, you have a differing site condition? Now, so for the Type 1, there's 3 general things you can do. One is look at the contract documents. So what were you given in the solicitation? What was referenced? Take a look back at those. Look at your site investigation observations. Hopefully you took some pictures, you took some notes. What did you see? And think about what maybe you should have seen. And third is look at the contract language. Are there clauses in there that try to modify the burden or shift the differing site condition from the government to the contractor. Now, one of the best ways to do this is to get a third party's perspective, get a fresh set of eyes, somebody else to look at this, not somebody within your organization who maybe has been dealing with this for a couple of years. It doesn't have to be an attorney necessarily, but even getting a buddy who works at another contracting shop can help in trying to figure out do you have a type 1 differing site condition. So for the type 2, this obviously is a little different. You still need to consider the contract documents in the site investigation as well, but you have this unusual requirement. So you need to think about your locale. Where are you at? Where was this constructed? What are the typical geological conditions that you were dealing with? In the end, I usually recommend to clients that for type 2, we generally have to be dealing with something that's fairly extreme to qualify to meet that high burden. A third way to do this is to hire a consultant. There are a lot of very good experts out there who deal in this, who can very easily assist you in looking at the data and looking at what you reasonably should have seen to determine whether it was a differing site condition. And fourth, you can also hire a construction attorney, somebody who's experienced in this area who can also look at that information and try to help you determine if you are dealing with a differing site condition or not. So notice, something that's very important with dealing with differing site conditions. FAR has a very specific provision on differing site conditions. And this essentially says a contractor has to give prompt notice and written notice to the contracting officer before the conditions are disturbed. The AIA A201 also has a similar provision, but as you see here, it gives an actual date in which it has to be given no later than 21 days after you first observe. Now, the purpose of this is to allow the government an opportunity to investigate. And second is to also allow the government to exercise some control over the costs to make sure that the contractor is dealing with it in the best fashion and not just running up the bill. Notice, notice, notice. Something I tell clients all the time, and this is true with about any different condition, but particularly with differing site conditions, is you must give notice, you must give it timely, and we'll talk about the best ways to do that. So notice of what? You want to give notice of, one, obviously the differing site condition, explaining in as much detail as possible. It doesn't need to be emissive, though. Second, cost impact. You don't necessarily need right away to give the cost impact to the government. And the cases bear this out because it's just probably not possible to do that. But a contractor will need to follow up ultimately with that cost impact if they want to get relief. So when give notice? ASAP, as soon as possible. A same-day email, if that's the only thing possible, followed up with a letter. The sooner you give notice, the better. And any delay may cause a loss of rights, as we'll talk about. So how do you give notice? There's no specific format required. There's no form. But written notice is recommended. And this is particularly when you're dealing with government contracting based upon the FAR, because it requires written notice. So to whom should you give notice? In the federal realm, the contracting officer is the person to give the notice because the FAR requires you to give it to the CO. And I would be wary of giving it to anyone else unless you're giving it to both an additional person and the CO at the same time. When you're dealing with state and private projects, you want to check the statute, check the regulation, check the contract, and make sure you're giving it to the person who is required to be given it under one of those statutes, regulations, or the contracts. And finally, there's a duty to proceed. And this is very true in the federal realm with the disputes clause. And this, in summation, says that the contractor has an obligation to continue performance even if there is any request for relief or a claim. So if you have a differing site condition, you have to keep performing on the project. Obviously, you want to document and keep track of your costs, but you can't stop the project. And what is the government's duty after notice? I wish it was as expansive as them becoming Sherlock Holmes. It's probably not the case. So the FAR and both AIA describe generally what's a contracting officer or architect's responsibility, and it generally is that they're supposed to promptly investigate. Not a whole lot of guidance on exactly what this means, but there are some cases that you find where the contracting officer delays in investigating and the government's found to have breached the contract. Now, the implied duty of good faith and fair dealing is something that's implied in every contract. And this requires, one, that the government has a duty not to hinder the contractor, and two, the government has a duty to assist or cooperate with the contractor. And this is also true in private contracts as well. Now, this should apply to the government's obligation to investigate. There's no case directly on this, but there is a recent case before the Federal Circuit, Metcalf Construction, that discussed this. And I believe that courts will hold that a government has an implied duty to timely and fully investigate an alleged differing site condition. And if the government does not investigate, a contractor may claim that there's a breach of the implied duty, which would lead to a breach of contract and could lead to an actual justification of stopping work. So what happens when you fail to give notice? Is the contractor out of luck? Is the contractor entitled to nothing? And their answer is maybe not. So here we have two FAR provisions. The first one deals with the fact that written notice has to be given unless there's an extension of time. And the second one, subpart D, deals with requests for adjustment after final payment, and essentially saying that contractor can't get equitable adjustment after final payment. And we'll talk about this in a second. The courts and the boards hold that the written requirements aren't construed technically as to deny legitimate claims where the government is otherwise aware of the facts. And the reason why is the reality of construction, fairness. And there's two requirements here, is if the government has actual or constructive knowledge of the differing site condition, they can't claim relief on those provisions. And so examples you may have is the government was present for the condition, the government even gave direction to the contractor, and there's been some cases where the condition shows up in government daily reports, and the government obviously just can't ignore that. Second, there has to be no prejudice to the government. We'll talk about that in the next slide. But at the end of the day, remember that FAR 52-236-2D, the one in the previous slide, stated that no equitable adjustment can be made after final payment. So in almost any instance, if a contractor accepts final payment, it's not going to be able to come back and get compensation for differing site conditions. So prejudice. This is one of those instances where the burden is actually on the government to show it was prejudiced by a lack of notice. And there's two types. One is if the notice might have minimized the extra costs. So this is if the government could have come in and directed the contractor to address a differing site condition in such a way so that they didn't spend $5 million as compared to $2 million. Second is the passage of time obscured the elements of proof. So if a contractor is giving notice a year later and the government had no chance to look at it, the government has no real way to dispute the differing site condition. And this is especially problematic if the contractor didn't take good records and documentation of the differing site condition. So seeking relief, and this is what differing site conditions is obviously all about, is additional compensation or extra time. So under at least the federal scheme, contracting officer under this FAR provision can give a equitable adjustment in the form of a change order, but they might not. And if they don't, then a contractor has to look at either submitting a request for equitable adjustment or a certified claim. Equitable adjustment is an informal method of requesting additional relief to a contracting officer. A certified claim is the formal process by which then triggers certain rights, and the contracting officer has to submit a final decision. And this leads then into the litigation portion here, is before a contractor in the federal scheme thinks of going to litigation, they have to get a contracting officer's final decision. There is an exception if the contracting officer is extending too long or is just essentially ignoring this. But without any of those exceptions, a contractor would be wary of going on to litigation. Second, there's the question of timing. You have certain time limits when you go to the boards versus the Court of Federal Claims. And then finally, venue. And in the federal scheme, you have a choice between the Board of Contract Appeals, so the ASBCA, and the CBCA, and the Court of Federal Claims. And there's differences between pros and cons of going to one of those venues. Under the AIA documents, there is a pre-litigation resolution. And I have these two provisions here, which we'll end up sending out to you in our slides. But essentially, these sum up that an architect can issue an adjustment, or the architect can decide not to issue an adjustment, in which case it has to notify the owner and the contractor and give the reasons. Now, under AIA document A201, if the contractor disputes the architect's decision, there is a section 15 which applies, and generally that states that the parties first have to engage in mediation, and then if mediation is unsuccessful, the parties have to then either arbitrate or litigate the issue, depending upon what is in the contract. So Colorado law, and I couldn't help but put a Broncos thing in here given the playoff game coming up on Sunday. So what is the source? There aren't any statutes in Colorado that deal with differing site conditions. We don't have the FAR here. There's nothing in the Colorado Procurement Code. There aren't any general regulations that apply other than for CDOT, which we'll talk about. There's very limited case law. And it makes it hard for us as attorneys to advise clients because there's just not a lot of wealth of law here in Colorado to know how courts are going to apply differing site conditions. But first, as I mentioned on the case law, there's really not much case law. We have one case, Kiewit versus City and County of Denver, and the only real holding from here is that a contractor has to follow the contract provisions before commencing litigation. The court didn't delve into any differing site condition principles in reaching its ruling. The second case did, URS Group versus Tetra Tech, and this cited to numerous differing site conditions clauses based upon federal law. However, the problem here is that this case applied New Jersey law, so it's really unclear if Colorado courts will rely on this case or not. If I had to give my guess, I believe that federal courts here would apply federal contracting principles because it is the most well-developed area of law on differing site conditions. So on CDOT, the source of its regulations on differing site conditions is the standard specifications for road and bridge construction, and this can be found in section 104.02. These are available online on CDOT's website. And it generally has type 1 and type 2 differing site conditions. The definition is very similar to the FAR. It also requires that notice similarly be given in a prompt written manner before the site's disturbed and work begins. And also it has a provision that the engineer for CDOT has to investigate and determine if a change order is warranted. So in the end, the CDOT regulations are very similar to the FAR provisions. So after going through all of that, let's talk a little bit about some best practices for you as contractors, subcontractors, owners, and anybody else involved in the construction government contract industry with differing site conditions. And one is understanding the contract documents. So what's in the solicitation? What are the reference documents? And really scouring those to understand what's in the boring logs. And if you don't understand those, it may be something to consider as to whether this is a job you should be bidding on, but maybe something you also just might need some help with. Second is conduct a thorough site investigation. And there are cases, actually numerous cases, where contractors didn't look at the entire site, or maybe they skipped a part of the site. One case I found a contractor didn't look at the whole site, and especially the key area, because he was scared of snakes. And second is, part of that is document it. Take photos, take notes, so that if we have to go back and look at what you saw, you have a record. Third, ask questions. If you have any ambiguities in the solicitation, if you find any discrepancies, don't bank on being helped out in the end. Ask the government. Fourth, hire a local geotechnical consultant. Especially if you're working in an area in which you're unfamiliar, get help. A little bit of time and money spent on the front end can really help on the back end of having to hire an attorney and being stuck in litigation. Fifth, consider conducting an independent investigation. And I say consider because it's not something you're required to do under the FAR or under most state or private schemes, but at the same time, you may want to do it anyway, just so you don't have the issue of having to deal with it and have to fight about it. And finally, understand your contract provisions on the differing site conditions, and especially any clauses or language that seeks to excuse the government or an owner for liability. And so understand what you're getting yourself into. If you're in the private realm, you may be able to negotiate some of that language out, or at least water it down. With the government, you might be stuck, but at least you should know what you're getting yourself into. So finally, what are some best practices after you encounter a differing site condition? And the first is investigation. And this is one of the key things that you need to do is find out what is the issue. And get help if you need. Hire a geotechnical consultant, hire whoever you need to fully investigate the condition. And then again, notice. I can't say it enough. Make sure the notice is written. Make sure it is timely. And then obviously, make sure it's submitted to the right person. Third, document. And this may seem obvious, but there are many instances where this just doesn't happen due to the pressing nature of construction and government contracts. So take photos. And how cheap memory is these days, take as many photos as you can. And the second line item here under document is cost records. And this is very, very important, is keep track of the costs. Track them. Make sure that at the end, you were able to match up the conditions that you encountered with your increased costs. And the key here particularly is to separate those out to the best of the ability you can, so that you're going to have obviously costs for your typical contract performance, but you'll have additional costs for your differing site condition. So the more you can do this at the time in breaking those out, the easier it'll end up being if you have to have negotiations with the government or the owner, or a court or board proceeding to show that you had a condition, here's how it differed, and here are the costs that you had. And finally, claim management. And the first part of this is preparation. Preparing a request for equitable adjustment or certified claim to the federal government, or it could be a change order request on a private job. And the key here is detail. Make sure you're describing the condition you encountered in enough detail and submitting attachments, so photos, daily reports. And in doing this, you may need to get help. Again, it doesn't need to be necessarily a construction attorney. There's plenty of consultants that can help in preparing this. But if it's something that you're unfamiliar with, you may need to get some assistance. And finally, follow through. And this can be done in an informal fashion of calling the contracting officer, calling the owner's rep, and following up on your claim. When you're dealing with federal contracting, if you submit a request for equitable adjustment, that isn't considered what's called a certified claim. And so if you want to prepare for the litigation process, you will have to submit a certified claim to the government before you can proceed. And finally then is litigation. If you've decided that you've exhausted all your remedies through the contract, through the regulations, and you're just not getting what you need, you may need to follow through on litigation. So this takes us to the end. We didn't have any questions submitted through the chat room, but if you have any questions, feel free to contact me. My email here is on this last slide and my phone number. I'm more than happy to speak with any of you if you have any follow-up questions. I appreciate, and Sherman and Howard appreciate you guys attending today's webinar on differing sight conditions. As we mentioned at the beginning, we'll be sending this out to all of you in the slides and the audio recording, and we look forward to hopefully seeing all of you at our seminar on February 26th. Thank you very much.